United States Senate candidate Sean Parnell suspends his campaign after losing custody battle. I want to go through this article today because it's an interesting intersection of law and politics. We're going to look at Mr. Parnell's decision, what he decided to do with his Senate campaign after this decision was made, but more importantly, how the decision was made for him to lose his custody battle. This article goes into that a little bit. I find it fascinating, but I think you'll also learn something about how the court system works. Thank you, everybody, for tuning in. I'm Joe Pometto, Joe the lawyer. If you like my content, please like, subscribe, comment, and share. Those are free ways to support the show. I'm still trying to get monetized right now. I am almost there, but any like, subscribe, share is a free way to support and help me get there. So another reason that I chose this article is because I live in the great state of Pennsylvania, and Sean Parnell is the Senate candidate in Pennsylvania. He's running as a Republican. He has not won the Republican primary yet. I also am interested in this article because I know the judges who are involved in making this decision. And you see in that photo right there, that's the Butler County Courthouse, about 45 minutes from where I live. And I've practiced up in that courthouse many, many times. So let's dig into this article. Hours after learning that a judge awarded primary custody of his 3 children to his estranged wife, Republican U.S. Senate candidate Sean Parnell said he cannot continue with his campaign. There is nothing more important to me than my children, and while I plan to ask the court to reconsider, I can't continue with a Senate campaign, Parnell said in a statement. My focus right now is 100% on my children, and I want them to know I do not have any other priorities and will never stop fighting for them. And I must say, I really respect that decision coming from Mr. Parnell. We'll take a look at the statement directly from him in a second. On Monday, Senior Judge James Arner issued an opinion saying that he found Lori Snell to be more credible in that he believed her when she testified about instances where Parnell got physical with her and their children. She provided factual details of each incident, including when they happened and what happened, he wrote. She testified in a convincing manner. Her testimony was not uncertain, confused, self-contradictory, or evasive. Arner said he found Parnell's testimony to be less credible. He simply denied that all of the incidents ever happened, Arner said. He was somewhat evasive. When weighing his position against Lori Snell's statements of detailed facts about many incidents, Sean Parnell's position is less believable. Lori Snell and Parnell separated in 2018. They have 3 children, ages 12, 11, and 8. During her testimony on the first day of the Butler County custody trial, November 1st, Snell alleged that Parnell had physically abused both her and her children. During his testimony, Parnell denied he had ever struck anyone in his family. In his opinion, docketed Monday, Arner awarded primary physical and sole legal custody to Snell, with partial physical custody going to Parnell. Let's scroll down here. On the docket, the judge wrote, Lori Snell was the more credible witness, and she can truthfully give regular status reports to Sean Parnell as may be needed to the court. Parnell was not immediately available for comment. He had been backed for the open Senate seat by former President Trump. In a statement issued by her attorney, Jennifer Vanisdale, Snell said she was grateful that justice prevailed. She will continue, as always, to focus on their best interests, the attorney said. Snell alleged during her testimony that Parnell would exhibit fits of rage, pin her down, and scream at her, and he struck one of the children in the back. She also accused Parnell of once punching a door that then struck one of their children in the face. During the 3-day custody trial, Snell also alleged that Parnell, who previously ran for Congress, travels extensively and is not able to provide the same level of care and attention to the children. Parnell's attorney argued Snell showed no evidence of a pattern of abusive or hostile communication. She also argued that Parnell is blending his family with that of his girlfriend for 3 years, and that the relationship provides additional support for the children. In his opinion, Arner wrote the 3 children who testified behind closed doors with just the judge and attorneys present, which is a common practice in the family law courts, in case you were not familiar with that, because testifying out in the open in a courtroom can be very stressful for children, and testifying in general is very stressful for children. So that practice is done in many, if not most, courts in the United States in order to take a bit of the pressure off, and also to not have the parents in the room, because the parents, if the parent is sitting there, it can influence the way that the child testifies. Love and feel safe. The children testified they love and feel safe with both parents, and that both parents provided proper care for them. Under those circumstances, he continued, it would seem both parents should have equal time and say in parenting decisions. That was the argument of Mr. Parnell's attorney. However, that arrangement has been tried and is not working, primarily because both parents refuse to communicate and compromise. Well, if you give a statement like that, it's hard to then make a decision against one parent. I don't know. Get them to cooperate. He said in his opinion that in determining custody, he considered most the children's need for stability and continuity, each party's availability to care for the children, and the level of conflict between the parties and their willingness and ability to cooperate. In the 15-page opinion, that's a pretty long opinion, Arner recounted the testimony by Snell, including her allegations of abuse by Parnell. He found Snell's testimony to be more credible because she could remember and describe the specific incidents she testified about. And let's take a second to do the same time sip. Since my mouth's a little dry, I'm getting over a bit of a cold here, and I need a drink to continue talking. Cheers. Arner wrote, he also considered how Parnell looked, acted, and spoke during his testimony. I mean, unless that's scientific. He was dressed very casually for his appearances in court in blue jeans and untucked plaid shirts, which did not show respect for the seriousness of the occasion. Ooh, Arner wrote. While testifying, he looked mainly in the direction of his attorneys and toward members of the news media in the back of the courtroom rather than at me. Ouch! In determining their credibility, Arner wrote that Snell and Parnell have motives that could affect their testimony. And that's true probably in any custody case and almost all court cases, unless you bring in independent witnesses. Parnell said Snell's motive was to embarrass him and damage his political career, while Snell said Parnell is motivated to preserve his public image and political career, the judge wrote. Upon consideration of the credible evidence, I find that Sean Parnell did commit some acts of abuse in the past. However, since the incidents involving Lori Snell occurred so many years ago and did not involve the children, they are not relevant to this custody determination. Therefore, Arner wrote, he did not make a finding as to what specifically happened. Arner said he did make a finding that allegations made by Snell regarding physical incidents with their children did happen. However, the judge said he did not place weight on those because they occurred more than 3 years ago and there have been no further incidents. Well, that's interesting. The fact that Lori Snell has agreed that Sean Parnell can have substantial periods of unsupervised custody indicates she does not view him as a threat of harm to the children. Yeah, this is very interesting. Further, the judge said the children did not express any concerns for their safety. In weighing other factors, Arner said Parnell moving out of the children's Seneca Valley School District to Sewickley weighs heavily in Snell's favor. Availability is a major factor in the case, Arner wrote. And I will back that up with the judge. One parent moving or one parent desiring to take the children out of the school that they're currently in is a huge factor. The parent who's not moving, if the current environment is stable and the children are doing well in the school, is going to have a significant advantage in a case like this. He also noted Snell's work schedule is flexible. She works from home and plans to remain living in the area. Parnell's frequent travel, particularly heading into campaign season, also weighs in favor of Snell. Arner said both parties are equally at fault for the high level of conflict between them and their failures to communicate effectively and compromise. In his order, the judge wrote that sole legal custody means the sole right to make major decisions on behalf of the children, including, but not limited to, medical, religious, and educational decisions. Both parents are entitled to full access to any records relating to the children, including school and medical records. When Snell makes medical or educational appointments for the children, she must provide notice to Parnell within 24 hours so that he can attend if he wishes. Now, the judge could have given Ms. Snell the majority of custody time while also allowing Mr. Parnell to retain, legal custody, or at least 50% legal custody. But he gave most of the legal custody also to Mrs. Snell. Couple things that I want to highlight here is, number one, judges are allowed to make determinations of credibility of witnesses, decide who's truthful and who's being dishonest. Now, your eyes roll a little bit when the judge thinks that they can read the body language and or lying or telling the truth. But I will say this, when you spend years and years and decades in a courtroom, you do start to pick up on something. And I'm not saying it's scientific, and judges can certainly be wrong, and so can attorneys. But I've watched enough testimony and sat in enough courtrooms that I think I'm fairly decent at reading people. Sometimes the way that they state things as well can indicate whether or not someone thinks they're telling the truth. And if they're evasive manner, or they talk in a third party and sometimes aren't clear and direct, I think those can be indicators of perhaps not telling the truth. I have no idea what happened here. I'm just reading into what Judge Arner said. Now, he cited all of those things about Ms. Snell telling the truth and being more credible, but then he said his decision didn't weigh on that. Do you really believe that didn't weigh on the decision a little bit? It's hard to say that it didn't. However, I do believe him when he says that the primary factor is that Mr. Parnell is obviously running for Senate. He's traveling all over. So it does make sense. It does make sense that she would have the primary custody, at least for the time being. However, the legal custody, I don't know. A word to say on the allegations as well of abuse. And again, I have no idea what kind of people these people are or what happened. I would just say that sometimes with things like that, when the other party just has a complete denial of what happened, and one party can describe in detailed incident of what happened, and the other party's defense is a complete denial, that is sometimes hard to believe. Because it makes the choice black or white. It's not that they differ on a few of the facts or how it went down. It's one person says it happened and one person said it did not. Usually the better strategy, and again, I don't know who's telling the truth or not, but if you have someone who's accused of acts like that, what you want to do as a defense attorney sometimes is have the person own up to it and tell and or cite or talk about how they've changed or what they've done to reform their lives, or that they feel a lot of remorse and regret for what happened. And that can actually come off as more authentic, and it will actually lead a person, a finder of fact like a judge or a jury, to relate to you you much more rather than flat out denials. Now, I don't know the truth, so perhaps Mr. Parnell is totally telling the truth. But some people really have a hard time admitting to things like that because they can sound so terrible in public. But I'm telling you that sometimes if you admit them, that can be the best way to go. You show remorse, and maybe the other party was talking about what happened, but you correct them on some of the facts. For instance, they said in there that he hit the door and it hit the child in the head. If that actually happened, and I don't know if it happened, I would imagine that the door, he didn't mean for that to happen, for the door to hit the child in the head. So it was an accident. And sometimes changing the way that the incidents are framed or controlling the way that they are framed is the most important thing and the best strategy. Like I said, the biggest factor is probably the Senate hearing and the fact that he was going to take them out of their school district, and she's still there living in the school district. That is huge. So I tend to believe those are the facts that matter. Judge Arner, I practiced before him. I did a trial before him. He's a good guy. I think he tries really hard to do a really good job on his case. I will just state the trial that I did with one of my colleagues ended up getting overturned. So the defendant, it was a criminal case, he was found guilty, and the reason it got overturned was because Judge Arner made a decision on an evidentiary issue that the appeals court deemed to be improper, and they granted the client a new trial, and that decision may have had a lot to do with the defendant losing that case. So I will say, though, that Judge Arner, I found him to be a very thoughtful judge who listens and tries hard to get the right decision. Now, I also want to give a big shout out to Sean Parnell because I think he did the right thing here. I mean, it's hard not to like a guy who sacrifices, his political ambitions in the now in order to focus on what's most important in life and take care of his kids. Sean Parnell released the following statement about suspending his Senate campaign. I strongly disagree with the ruling today, and I'm devastated by the decision. I plan on asking the court to reconsider this decision. In the order, two of the leading factors that weighed heavily in the judge's decision revolved around me being a leading U.S. Senate candidate. There's nothing more important to me than my children, and while I plan to ask the court to reconsider, I can't continue with a Senate campaign. My focus right now is 100% on my children, and I want them to know I do not have any other priorities and will never stop fighting for them. Thank you. What a tremendous statement there, and really, I just have to give a huge shout out to him for putting his family over politics. Tremendous. So, there's 16 factors. I was going to go through them. There's 16 factors. Every state has factors like these: need for stability in continuity in the child's education, availability of extended family, child, sibling relationships, things like that. And that's what the judges weigh when they issue those orders. So, very interesting case. The one piece of advice I would have for Mr. Parnell is next time, wear a suit, sir, especially when you're a leading Senate candidate. And look, I'm not saying wear a suit on the campaign trail. Do what works for you on the campaign trail. But in the courtroom, and I did a video on this, perhaps I'll do another one, the way you dress matters. I'm not walking in my Captain America suit, okay? My Captain America shirt. I wear a white shirt every single time I am in the courtroom because I believe it reflects the highest level of professionalism. Thank you for tuning in to Joe the Lawyer. I hope you like this content. Please like, subscribe, comment, share. I hope you learned something. Thank you very much, everybody. Love you guys. Have a nice night.